Good morning and welcome to our webinar on financial wellbeing. My name's Jenny Burke and working alongside me today are my Leukaemia Foundation colleagues Linda Saunders and Megan Moore, and together we'll be hosting today's seminar. So it's National Reconciliation Week and their theme is now more than ever. And now more than ever, I'd like to acknowledge the traditional owners of all the lands that we're coming together on today. And I want to recognise their continuing connection to land, sea and community. I want to pay respects, deep respects to elders past and present for their ongoing and commitment to culture and traditions, and to any First Nations people joining us today. Before we launch, a quick reminder that there is a chat function at the bottom of your screen and you can add a comment or a question in there at any time. And we know that you'll be very respectful in your comments and considerate in your responses. We do have a question and answer session at the end of the webinar, and we'll be answering a lot of the questions that you've pre-submitted, but we'll also consider what's in the chat. For the best experience, you might want to put your screen on speaker view, and a reminder that this is general advice only, and that if you have very specific and personal questions, we do recommend that you seek professional help. So let's get started. When diagnosed with a blood cancer, many people worry about if they'll be able to continue working, to earn an income and pay for their living expenses. And we know that people dip into their savings and their superannuation to survive long periods of treatment without income. We also know that treatment may be prolonged and require significant travel or relocation, depending where you live. So the financial impact will be different for everybody, but we know that it can place stress on relationships and your well-being. So in today's webinar, we'll be looking at what you can do to manage your finances now and into the future. And to help us with that, we're joined by Antony, Lee, Natalie, and Sharon. And to set the scene, we are really fortunate to have Sharon with us to tell us a little bit about her experience with the financial roller coaster and fallout after her blood cancer diagnosis 14 years ago. Thanks, Sharon.
Hi guys, welcome. I am almost 54 years old and I was diagnosed 14 years ago, 2 weeks after my 40th birthday. To say I was shocked is just an understatement. Actually, I get quite emotional thinking of that diagnosis, but I was managed, it was fine. I was told it was chronic and it would be looked after and I would be just fine. Within 2 years, things changed dramatically. I was placed on numerous clinical trials. I could no longer work. I was very, very sick, but also I had to travel down the track. So I moved to Adelaide, but that was not an easy road. I was terminal a few times during that 14-year journey. I was told there was nothing left for me, and then a clinical trial came up in Adelaide. As you can understand, costly, because we do not have any sort of help from the government, but we do have the Leukaemia Foundation. And without them, I wouldn't be here today. So with the help of the Leukaemia Foundation, I was relocated to Adelaide. I lived in the Leukaemia Foundation. They helped me with my travel, with my accommodation, with so much. I don't even know where to begin. Prior to that, I did have to finish work. I had to access my super. I had to access my income protection. It is such a heavy burden having a blood cancer diagnosis and not being able to fund it yourself and the treatment and keep working. When I moved to Adelaide, that was the biggest step ever. I had to leave my family. My partner was able to come and stay, but we did stay at the Leukaemia Foundation. They helped with transport. They helped with food. They helped with everything. My mental health, my partner's mental health. They were there for us through everything. And without that, we wouldn't have been able to afford counsellors, afford anything. I'm just trying to think what else. There were so many. You can access, fuel vouchers, shopping vouchers, assistance with financial advice. There's so much to talk about with it. After I got back from Adelaide, I had to travel every 4 to 6 weeks for blood tests and, more treatment and checkups and you name it. So I couldn't work because of that as well, but also because I was so unwell. My daughter had to do a fundraiser. A girlfriend had to do a fundraiser. The financial burden is more than you could expect. Oh, I thought why did I have to move to Adelaide? Sorry, I just saw that come up. There was nothing available here in WA. So I had accessed all the clinical trials that were available here. I think it was at the 5.5 year, almost 6 year mark that a clinical trial came up in Adelaide. I was actually even on the Channel 9 news because we tried to access the Patient Assistant Transport Scheme, the PAT, and they refused because I was not on cyclical chemo. I was on oral chemo every day. Had I only been on chemo 7 days off, 7 days on, they would have assisted, but because of all the red tape, it just didn't it didn't work out. I had to end up selling my house because I couldn't. I ran out of income protection. I ran out of what super I could access. I couldn't keep up the payments anymore because obviously I wasn't working. And asking for help as women, as men, as everyone, but especially women, especially strong single parent, I didn't want to ask for help. It was my pride in the way, but I had no choice. Do not be afraid to ask for help. There's so much help out there, with the Cancer Council, but mainly with the Leukaemia Foundation. They're there to help you, and they will help you in every aspect. Like I said, with my family, with my partner, with myself, they helped so much that I would not be here today without their assistance. I will probably never own another house again because I am 54 and I can't see them giving an old girl a loan right now, but I am back working full time. I have had a bone marrow transplant. I get the all clear on the 21st of June, cross fingers, but just money's not everything. It really, your health is just number one, and you really have to just bite the bullet, ask for help, do whatever you can to get that treatment, to access whatever you need, okay? Anyone got any questions ever, please feel free to reach out. And someone said, I'm watchmate, but there's no way that I could ever afford treatment. I've turned down past. Don't turn it down. Access anyone you can. The Leukaemia Foundation, if they cannot directly help you, they will find a way, believe me. They are the best support I've ever had. So, don't be afraid to ask for help.
Thanks, Sharon. What a story. I think you're extraordinary. And the thing that really came through for me when you talk about this is you've really been to the financial pits and back, pits of hell and back, and, having to sell your house, use up all of your resources to do that. And I know when we've talked, you've talked about the amazing support from your partner and from your family, and coming to that place where you realise money isn't everything, but it doesn't make it easy. So thank you for sharing. It's such a personal story. So now I'd like to introduce Antony Mitchell. Antony has an extensive career in finance, particularly in the banking and financial markets and in public service, including with Treasury and the Reserve Bank. He embarked on a change of career with a greater focus on community and has worked with several not-for-profit organisations as a financial counsellor ever since. And up until recently, Antony was the lead financial counsellor with Cancer Council Victoria. And today we are very grateful and lucky to be able to draw on his experience. Thanks, Antony.
Thanks, Jenny. I'll just get that up and we'll get going. Is that all right? How's that looking, Jenny? Great. Okay. Well, welcome everybody, and thank you for the opportunity to speak, Jenny. So I might just get things arranged on my screen. So basically the run of the next 20 minutes or so is I'm going to talk about income, then I'll talk about debts, and if we've got time, expenses. I'm going to focus as much as possible on income, because clearly if you can find income options, a lot of the worries about debts and expenses go away. As Jenny said before, this is of a very generalist nature. Everyone's at a different age and stage, and indeed everyone is going to have a different treatment path as well. So that changes the game in many, many different ways. So if you are after advice on this beyond our discussion today, you can talk to your accountant. If you have a financial planner, talk to them. But also Leukaemia Foundation and Cancer Council have really great resources. I know there's a really good team at Leukaemia Foundation who are well across these things, and if they don't know, they can direct you to someone who does. So on the income side, we're going to be talking about 4 things. The first one is, assuming you've just entered into a diagnosis, and it's, hell, I'm going to be off work for 3 months or 6 months or whatever, even longer for many leukemia patients. Blood cancers are quite difficult things to deal with. First option is employment. You're going to have leave entitlements. You may have long service leave. It might be possible to talk to your employer about doubling the length of that long service leave by going on half pay. A lot of people are quite reluctant to talk to their employer about their diagnosis. My experience with thousands of patients is that not always, but quite often, employers are actually very sensitive to this, and many of them will go beyond in many ways. I've seen employers do some quite extraordinary things in this sort of situation. The second source of income is going to be savings. Now, when I talk about savings, I'm not just talking about savings in the bank. $10,000 to $20,000 may help, but it may, if you've got a treatment path that goes for 6 months, it's not going to be there. But sometimes people have other assets. They have their own share portfolio, or they have investment properties. My one observation is that when people have investment properties, particularly if those, even if those properties aren't generating an income, they're very reluctant to sell them. My only comment on this would be basically that if your treatment path goes beyond when you're expecting, having to sell property in those panic moments, hell, we're running out of money, is considerably more difficult. So carefully consider whether hanging on to that investment property is realistic for you, or whether it gives you liquid resources, because the issue here is that property is not always that liquid. If you have liquid resources, it takes away some of the economic stress of going through cancer treatment. The third one is super. Now, there's 2 aspects to super. There's actually accessing the super, but before you even contemplate accessing super, ask your super fund what insurance you've got. Frequently, people have insurance in super and they don't know what they've got, or they're dimly aware of it but aren't aware of the terms and conditions that that insurance is available to them. Commonly, the insurance that people will have, one or all of the following 3. The first one is income protection. Now, that's a monthly payment. It can vary from $1,000 a month, which is actually not that much help, through to 80% or more of what you were earning before you got ill and had to stop work. Typically, those policies have a 60 to 90-day wait, and typically they run for a couple of years, but I've seen policies that run for 5, and indeed some that run to age 65. So And it's important with income protection to, once you have stopped work or are contemplating stopping work, to get those claims in. As a side note, most people find their super fund exceptionally frustrating to deal with. And to some extent, some of them make Centrelink look easy. Forewarned is forearmed. They may not make it that easy for you, which is a bit annoying since we all pay fees for this service. But anyway, that's been my experience. Not always as good as it could be. So get the claim forms for income protection first up. The other two types of insurance you're going to find in super is TPD, total and permanent disablement. That's a lump sum payout, and it can be anywhere from $5,000 to hundreds and hundreds of thousands of dollars. And a little anecdote, I had a multiple myeloma patient a while back who swore black and blue he didn't have any insurance in super. He was on his 4th round of treatment, so it was becoming quite difficult for him to sustain the treatment. And he was going to be going on the disability pension, and lo and behold, he all of a sudden found he had $700,000 of insurance after we sort of insisted that he ring his super fund. So definitely check it out, because it certainly changed this guy's life. He was able to live quite independently as a result of checking this out, even when he thought he didn't have any. So to get TPD, generally the definition is that you can't do your old job ever again. The doctor has to, so a specialist has to sign off on that, and another doctor has to sign off on it typically. There are other definitions, but that is the most common one that you will find within super funds, that you can't do your old job ever again. So it doesn't stop you from working again, it just is you can't do your old job ever again. With blood cancers, that could be due to fatigue. I know with, for example, breast cancers, when people get very bad lymphedema and they work in childcare, they can't pick up kids anymore, so you can't work in childcare anymore. But it doesn't stop you from being a teacher, for example, if you don't have to pick up the kids. So that's TPD. And the last type is life insurance, also more commonly known as death insurance these days, but like TPD, where you don't have to be totally and permanently disabled, you don't have to die to get this insurance either, but you do have to have a doctor sign off on a terminal prognosis. Typically that needs to be a couple of years. For some policies, it's 12. Often I see doctors, because a prognosis is essentially an educated guess, I see doctors, if someone is at stage 4, which I know is not relevant for blood cancers, but if someone is at stage 4 with a solid cancer, doctors will often sign off on that policy, and I suspect sometimes they don't really believe that 2-year prognosis is the patient's story. So it very much depends on how supportive your hematologist or oncologist is as to whether you can get that one over the line. Like TPD, it's a lump sum payout. The only other thing to talk about here is that often TPD and life insurance are linked. Broadly, what that means is you can claim one but not the other. So if you have $100,000 of TPD and $100,000 of life, if you claim the life insurance, you don't get the TPD anymore. It's a way of lowering premiums but providing 2 different forms of cover. Okay, accessing super. I'm going to skim over the accessing it, what you can access over age 60. Suffice to say that once you've hit preservation age, you can retire. And if you retire and convert your super to a pension, then you have full access either by lump sum or payouts to it. If you're under 55, it becomes more difficult, or under preservation age, I should say. For most people, preservation age these days is 60. But for those of us who are a bit longer in the tooth, it's our late 50s. So there's 3 ways to access super. One is on hardship. Now that just requires the trustee of the super fund to sign off on it. You typically will need, every super fund has their own criteria for this to some extent. The trustees need to sign off on it, nobody else. Often you need to have been on Centrelink and have been on Centrelink for 26 weeks continuously, and you have to demonstrate that you can't pay your living expenses. Typically, the maximum amount you'll get is $10,000, and that's usually taxed somewhere between 18 and 22%. So, for example, if you got $10,000 out, you'd get $8,000 in the hand. It's a bit of it's an expensive way to access your super. The second grounds for accessing your super is compassionate grounds. There are 6 criteria for that. They're around affording your medical treatment or transport for your treatment. If you are running into serious arrears on your house and they're getting close to foreclosure, and I mean you have to be very close to foreclosure to access us on these grounds, or to make modifications to your house for a disability or pay for palliative or funeral costs. Getting access to your super on compassionate grounds is more money than $10,000. It's a sort of upwards of $40,000. Again, you will get taxed on it, and there's an additional barrier in that the trustees and the ATO have to sign off on this. So again, quite difficult to access. It's a bit of a last step if money, there's no other money elsewhere. The last grounds is terminal medical grounds, and that has the same criteria essentially as life insurance, that the doctor signs off on a prognosis of 2 years or less. There is one more called permanent incapacity. So if you are younger than preservation age, you can access that money on permanent incapacity. The only one of the, and again, that one is taxed. The only one that is not taxed is terminal medical illness. And again, that requires the ATO and the trustees to sign off on that, and it requires a doctor to confirm that prognosis. So that's super, insurance and super and stuff. With Centrelink, I'll just skirt over that. For those people who expect to go back to work, pretty much the only option is job seeker with a medical exemption. If you're single, it's a bit over $800 a fortnight. The doctor will have to give you a medical exemption, and that will have to be renewed every so often, hopefully every 3 months, but sometimes they require more frequent updates. The only other thing to access on Centrelink is a thing called carer allowance. If you have a partner or a significant other who are running around and doing some part-time work, taking you to appointments and things like that, carer allowance there's a relatively low barrier to entry there. It's about $140 a fortnight, so you're certainly not even going to feed yourself on that, but it's something, and there's a relatively low barrier to entry to carer allowance. In the long term, if you find you cannot ever go back to work, then the disability pension is the option there. It's a bit over $1,000 a fortnight. I should mention with Centrelink, if you do get a benefit, you get a healthcare card, and that healthcare card can be worth a couple of $100 a fortnight just in saved medicine and utility costs as well. So back to the disability pension. You can get the disability pension if the doctor will sign off on the terminal and 24-month prognosis very quickly. Like, I expect it to happen within 2 weeks to get the disability pension. Unfortunately, with blood cancers, that's a less frequent occurrence. Hematologists are a pretty optimistic lot, and it takes quite a few cycles of treatment to get, typically to get hematologists to sign off on that, but not all, but many. The other way of accessing the disability pension is through the usual route, and that requires 20 points of impairment. That is going to take months and months to get through, and is very, very difficult for all cancer patients, including blood cancer patients. So it's a process that just requires a bit of persistence. The other thing available in the long term is if someone requires full-time care, there's carer payment. That's, again, for a single person, a bit over $1,000 a fortnight. So that's available to carers of patients if they're doing that full time. So let's get on to the next slide. which is debts. And we're going to zip through this very quickly. Basically, the biggest stressor I find for people when they came to me with help, I'm going to be off work for 6 months, is how am I going to pay the mortgage? First of all, check that you don't have insurance in the mortgage. Some people have insurance that will pay their mortgage while they're ill. So that's the first thing to check. And again, a little bit like insurance and super, a lot of people don't know they have it. This one is more rare, so it's quite possible you won't have it, but certainly if you don't ask, you definitely won't get it. Broadly, in credit law, the law says that if you give a loan in good faith and then life happens to someone, you must take that into account. That's what the law says to creditors. What the law doesn't say is what they should do about this. And what I see more typically is that if someone has difficulty paying the mortgage, ring up the bank and tell them your story. Again, people are often very sympathetic to a cancer diagnosis. Most people have been touched in some way. So like your employer, get onto them and tell them how it is for you. What you could expect if you're off work for, say, 3 months or longer is for the bank to put you on interest only for that period. More rarely, they will do no payments at all. That's a bit of a last gasp because clearly they will still charge you interest and you'll end up, that will add to the capital that you owe. So you'll end up effectively paying interest on your interest. So if you can, if you do need to go to interest only, go only to interest only. Similarly, personal loans, you could expect similar treatment, but with personal loans, particularly unsecured ones, banks have a few more options to pull. One of them would be obviously to get the debt completely waived. Pretty much that requires the bank to lose all hope that they'll see any money in the next few years as a minimum for them to waive the loan. So you hear of them in the community, but they're not as common as you might think. Another option might be if you got I've had a few patients do this, they got insurance payouts, they negotiated they had a credit card debt or a personal loan debt. They said, okay, I owe you $10,000, but I've got hold of $5,000. Will you accept $5,000 as full and final settlement of this debt? So the thing to do with banks is ask to speak to the hardship department. Don't just speak to customer service. There's a dedicated, often in banks, there's a dedicated group of people that do this who have authority to make changes to loans. So go to the bank, ask to speak to the hardship department, tell them how it is for you financially. Ask them what they can do for you, because sometimes they'll offer you more than what you were going to ask them. So give them the opportunity to do that. That's a rare thing, but again, if you don't ask, you don't get. And also go into it having an idea of what you would like them to do and then ask for it. So that's pretty much debts. I realise we've probably run out of time, Denny, but I'll just whiz through the expenses. Informed financial consent, basically when you're going into treatment, the MO now is they've got to tell you what the costs are and use the term informed financial consent. I was going to talk about the PBS safety net, but we'll skip through that. If you want to know about that, it's basically once you hit a certain amount of spending on medicines, you'll hit the safety net and you will get either free medicines if you're on a benefit or very low costs medicines. Consider your budget. I'm sure most people are across this, but now's a bloody good time to be reconsidering that. Do you need 6 streaming services? Would 3 do? Et cetera, et cetera. And also my other point here is make sure you're not paying the loyalty or otherwise known as lazy tax on your insurance and utilities and stuff like that. So with that, I'll leave it there and let Jenny try and get back on schedule.
You did very, very well. Linda's been busy putting links in the chat to things like Money Smart and the National Debt Helpline. So keep checking the chat, and we can always send those links again if people need. Thanks, Antony. It's just so huge, this topic, and I think you did a remarkable job. So finally, we're going to ask our presenters from Brydens Lawyers to talk all things wills. So we have Lee and Natalie with us. So Lee started his career in law at Brydens after graduating, I'm just going to say in the 1980s, Lee, and he's now the principal at Brydens Lawyers. And during his career, he's been accredited by the New South Wales Law Society as a specialist in personal injury law. He served as a member of the New South Wales Law Society Injury Compensation Committee. He's been appointed to the University of Wollongong Advisory Group for South Western Sydney, as well as an arbitrator of the District Court of New South Wales. And he's represented the legal profession on the Injuries Advisory Committee of the Law Society for several years. He's a very esteemed lawyer. Brydens partner with many corporate, sporting, charitable and community organisations to give back to their community, and we're really grateful for them being here today. And Natalie is a senior associate and accredited mediation practice manager in the family law, wills, estates and probate division at Brydens. She exclusively practices in family law and estate law, and that's enabled her to represent, advocate and help clients during some of the most difficult periods in their life, which she finds rewarding and fulfilling. So over to you, Lee and Natalie. Thank you.
Thank you very much, Jenny, for those warm words. And I'll share the screen. Very honoured to be here today to be presenting with Natalie, who is a senior associate for Brydens Lawyers. And given that we are ageing ourselves, I can let you know Natalie's been with the firm for 17 years. And no, she did not start with the firm when she was 10 years of age. So just sharing. Okay, so I assume that can be seen. Moving forward. Just wanted to pick up very quickly on something that Antony was saying about TPD, total and permanent disablement claims. You'll see on the screen there, we do that sort of work. And unfortunately, it's a growing area because of the resistance and pushback by insurance companies to claims or valid claims made on superannuation funds pursuant to the TPD policy for people who cannot work, not only by reason of injury that occurs at work, but also by reason of illness, as Antony pointed out. So if anyone is unable to perform their usual occupation for a qualifying period, it's usually 3 or 6 months, then they can bring a TPD claim, which can be very worthwhile, can be worth a lot of money to them. And it's an insurance policy to which they have contributed themselves. So if that's anyone listening today, they should really contact the firm for further advice. Today we're presenting on wills and estates. It's a very large and potentially complicated area, so I'll try and provide a detailed overview and simplify it to the extent that I can. We, of course, at the end of the day, will take questions, but anyone that's interested in seeking particular advice will be able to contact the firm, and I know that we'll be providing those details later. A will is simply put a legal document prepared for the purpose of setting out how you would like your estate distributed following your passing. It can identify all of the beneficiaries, that is those persons that will actually receive your assets upon your passing. That could be family members, it could be charitable organisations, it could be community groups. Now, the most common wills that we see are, of course, for couples, whether they be married or in a de facto relationship, usually providing for all the assets to pass from one partner to the other, and then to the children on the passing of both spouses or partners. Now, alternatively, a will can be a very complicated document, particularly if we're dealing with testamentary trusts, family businesses, or things of that kind. Now, there is also an option for spouses or partners to enter into a contract to make a mutual will. And what that provides is that both partners agree to make a will. Then following the passing of one partner or spouse, the remaining partner or spouse cannot change the terms of the will. And of course, we know that can be a concern for many people. that once their partner passes, they inherit the estate in its entirety. There's nothing to prevent them from remarrying or taking up in another relationship. And then questions arise as to whether those assets will eventually be passed on to the children of the original relationship or to others. So to prevent that from occurring, spouses or partners can enter into a contract to make a mutual will. Now, making a will in itself can be a difficult task because facing your own mortality is not something that's particularly pleasant. And I know that if we asked for a show of hands, if that was possible, and I asked how many people here have in fact a will, I would not be surprised to see that the majority of people listening today do not have a valid will. It is not a difficult task to prepare a will, but it is something that you need to confront and then approach solicitor for the purpose of doing so. And again, we'll address that later as to how you go about doing it. But it is something that we need to address. It's an important document to ensure that your wishes as to how your estate is to be distributed are fulfilled. Now, the importance of a will becomes very paramount where there may be a complex family dynamic, including ex-spouses or partners, blended families, stepchildren, estranged members of the testator's family. And now, with the benefit of expert legal advice, you can adequately address those situations to ensure that your wishes will be carried out. Now, for a valid will, a number of legal requirements. It must be in writing, must be signed by the testator. Now, the testator is, of course, the person making the will. There must be 2 witnesses, and they must also witness your signature and execute the will in your presence and in each other's presence. There are provisions under the Succession Act in New South Wales and elsewhere, of course, for a will to be held valid if it does not fulfil all of these testamentary requirements. We know of instances where a person may have prepared their own will when facing death in some tragic circumstances. An application can be made to validate that will, even though it hasn't complied with all of the legal requirements. You need to appoint an executor. An executor is someone over the age of 18, someone that you can trust, someone that will stand in your place to distribute the assets under the will, to distribute the estate to the way that you want. Most often we'll see that that person will be a spouse or a partner, adult child, a friend, a relative, lawyer, or other professional, or in fact, it can be a professional trustee company. The responsibilities of the executor are many, including collection of all the assets, paying of debts, paying of testamentary expenses, and then distributing the estate. Now, there is an obligation, of course, to pay the estate's debts upon your passing. The executor will collect all of the assets, use them to satisfy the debts, and the failure to do so can expose the executor to personal liability. The debts are attached to the estate, not to the beneficiaries or any other particular individual, and therefore the executor will collect the assets and pay off the estates. Now, if there are insufficient assets in the estate to meet all of the liabilities, the estate is considered an insolvent estate, and the executor will then treat it the same way a bankruptcy trustee treats the estate, contacting all the creditors to let them know that the debts cannot be paid, and therefore, of course, there'll be no assets available to any beneficiaries. Now, specific requests can be made pursuant to a will, items of jewellery, furniture, clothing, for example, that you may want to go to a particular beneficiary. It can also include a sum of money that you wish to allocate to a beneficiary or to a charitable organisation or to a community group. A testamentary trust can be prepared on behalf of the testator pursuant to the will. What that means is it's simply a trust that's prepared under a will or some other document. It's a trust prepared for the benefit of infant children who are not old enough to receive the bequest directly, or it can be prepared on behalf of those who lack a legal capacity. Now, we'll talk about that later. But special needs children, for example, who will never be able to manage their own affairs, may have to have a testamentary trust prepared for them. So a trustee is appointed. That may be the executor, it may be another professional trustee organisation, to manage the estate on behalf of the child or adult who lacks legal capacity. On the other hand, if it is a child that does not lack legal capacity, you may wish for that child to receive the benefit of the estate when they're an adult at 18 or 21 or 25, for example. That's something that will be specified under the will. Now, are all wills valid? If they comply with the requirements of the legislation, the answer is yes. Can any will not be the subject of challenge? No. Every will is open to challenge, and there are three grounds upon which a will can be challenged. Firstly, if the testator lacks legal capacity. Secondly, if there is any undue influence on the testator to prepare a will in a particular way. And thirdly, if an eligible person was excluded from the will. Now, legal capacity can be a very complicated concept, but in essence, it provides that a person must be capable of managing their own affairs and giving instructions to a solicitor to have a will prepared. There's no loose definition of insanity or anything of that kind. It's a legal test to determine whether or not the person has got capacity in order to prepare a will. Otherwise, it will be the subject of challenge. Now, as provided for, a person's mental capacity is not assessed by the way they look or present or communicate or the way that they behave. You may not agree with the way a particular person behaves or what they have done so far as their will is concerned, but that does not determine their legal capacity. It is a legal test, usually determined by reference to medical evidence to determine whether or not the person has capacity to manage their own affairs and therefore prepare a will. If not, the will can be the subject of a successful challenge. Undue influence, again, a person is coerced or persuaded or influenced in the making of their will in a particular way. If that occurs and can be established to the court's satisfaction, the will may be set aside. Who is eligible to contest a will? Well, there are persons provided for under the Succession Act in New South Wales and the equivalent legislation throughout Australia that provides that an eligible person has a standing to contest a will if they were not provided for in the will or not adequately provided for. That can be the wife or husband, the partner, a child, a person who is dependent upon the deceased, or a person living in a close and personal relationship with the deceased at the time of their death. If they are not provided for, then they can actually challenge the will. Does not necessarily mean they will be successful, but they are entitled to challenge. Eligibility, again, these are the things that are looked at by the court to determine whether or not the eligible person will be successful in challenging. They look at things such as the person's means and needs. So even if the eligible person is determined under the legislation to be eligible to make a claim, if that person cannot establish a need to do so, they will not be successful. The court will look at the size of the estate, the age of the party, the obligations of the deceased, the conduct of the party before and after the death of the deceased as well will be relevant. Family provision claims in other jurisdictions set out there briefly. So similar legislation operates throughout all of Australia to identify persons who are eligible to make a claim and look at the grounds upon which they can make a claim to determine the success of such an application. Limitation periods in New South Wales, there is 1 year from the date of the death of the deceased in which to make a claim. You'll see the other jurisdictions provided for there. Queensland, for example, 9 months. Tasmania, 3 months. But that's from the grant of probate or letters of administration, which can take a little bit of time. There's also provision for the extension of time in certain circumstances. You'll see at the bottom of the page the grounds upon which an application for an extension of time can be made. They'll look at the length of time that has passed, the circumstances of the applicant, and whether other beneficiaries may be prejudiced by such an application. A statutory will is one made on behalf of a person who lacks the legal capacity to do so. Person suffering from dementia or some other serious type illness who has not prepared a will, then someone who has a close connection to that person can make an application to the court to have a will prepared for that person in the terms that would have been prepared by that person had they not lacked legal capacity. And that's determined by the court on the basis of evidence that's available and presented to the court. And the court will then, in essence, draft a will for that person on the basis upon which they believe that person would have prepared a will had they not lacked legal capacity. So if a person does suffer such an illness, a close family friend or family member who lacks the capacity you believe would be best served by having a statutory will prepared, then an application to the court for them and on their behalf can be made. Where there is no will, the deceased dies intestate, and there are very strict laws that will then apply as to the distribution of the estate. It may therefore not be in accordance with the wishes of the deceased. This table sets out what happens when a person dies without a will and in particular circumstances. So you'll see where the deceased passes, leaving a spouse and a child, then the spouse is entitled to the whole of estate. You'll see further down where there may be more than one spouse, which is a bit curious, but there may be more than one spouse if the deceased was married and had a de facto spouse or more than one de facto spouse, then the spouses are entitled to equal shares of the estate. And the table goes through what happens in other circumstances. Letters of administration is an application made to the court for the distribution of the estate where there is no will. A relatively straightforward process. The application is made by a close family member or someone who has an interest, and you'll see there at the bottom of the page how the next of kin order is set out for the purpose of making this application. Letters of wishes, also known as a statement of wishes, is simply a letter or a document that's prepared by the deceased and placed with their papers. It is something that the court can have regard to for the purpose of appointing a guardian for infant children, or explains why certain people benefited or why people did not benefit under the will in case there is a challenge. The letter of wishes is not a legally binding document, but it is a document that the court will have regard to in the event that there is a claim on the estate. Probate and letters of administration throughout other jurisdictions follow a very similar course as it does in New South Wales. A power of attorney, another document that people should give consideration to. A power of attorney, many of you would be familiar with. You appoint a person to be your attorney, to manage your financial affairs on your behalf, to deal with bank accounts, to pay bills, for example, to pay other invoices that fall due. You don't have to lack legal capacity to appoint an attorney. We often see it when someone travels overseas and appoint someone an attorney to look after their affairs here in Australia. However, an enduring power of attorney differs, and significantly. It is a document which provides that you appoint an attorney to manage your affairs when you no longer have the capacity to do so. So, for example, if you take ill, and the moment that you lack legal capacity, it triggers the appointment or the activation of the enduring power of attorney. Your attorney can manage all of your affairs when you are incapable of doing so, paying your bills, paying medical bills, paying hospital bills, dealing with banks, dealing with insurance companies, making claims on your behalf. A very important document that people should consider, particularly in case of illness or infirmity as we all get older. Similarly, an enduring guardianship provides for the appointment of a guardian to manage your affairs when you lack the legal capacity. Ordinarily, we prepare the enduring attorney and the enduring guardianship together. They differ significantly. The attorney is concerned with the management of your personal and business affairs, so far as management of finances is concerned. The guardian is more concerned with healthcare and lifestyle decisions. Will make a decision with respect to where you live, what doctors you have treatment with, where you are admitted to hospital, what decisions you make with respect to nursing care. So whereas the attorney looks after the finances, the guardian makes decisions with respect to your lifestyle and treatment decisions, which is very important. You can, of course, appoint the one person to be the attorney and the guardian. Well, that's an overview. This is who we are. We can assist, of course, by the drafting of a will, drafting of powers of attorney and enduring powers of guardianship. We can discuss with you the terms of your will. We can discuss with you all of the documents that you may or may not require, and we can fashion them to suit your personal circumstances. So thank you very much for the opportunity to address you today.
Jen, you're on mute.
Sorry. Well, thanks, Lee. It's fantastic. I think you and Antony have both taken us through some very complex topics very clearly, and looking at the chat, people have really appreciated unpicking these things in a really clear and thorough way. And I can also appreciate that both of these topics could have probably had an hour on their own. So I'm going to hand over now to Megan to go through some of the questions that we've had submitted and ask our panel. Thank you.
Thanks, Jenny, and thank you to all of our speakers, Antony, Lee and Sharon. You all did such a beautiful job. Thank you for sharing all of that with us. We've had some great questions in the chat, and thank you to Linda for proactively answering those and sharing some of those really beautiful links as well. We did also receive some questions at the point of registration for the webinar, and some of these have been really beautifully answered and covered throughout your presentations today. We've also just got a few others that we'd like to ask our speakers. So with that in mind, the couple that I sort of wanted to start with, just because we've obviously just done the presentation with you, Lee, is around those sort of wills based questions that we've had. So you obviously mentioned that you'd be able to support people if they were sort of wanting to put together that will, but is it necessary to approach a lawyer to prepare a will? And what might sort of be a rough estimate that people might expect to pay if they were developing a will with a lawyer?
Thank you, Megan. The answer is no. Strictly speaking, it is not necessary to engage a solicitor to prepare a will. You can go and purchase will packets. The New South Wales Trustee and Guardian and the similar organisations in other states will provide that to you. However, having said that, given the importance of the document and the legal technicalities required to be complied with to ensure a will is valid, and that it sets out in details the wishes of the testator, my strongest recommendation is that you engage a solicitor to prepare the document. Relatively speaking, given the value of people's estates, a will is a very, very inexpensive document to have prepared. A single will might cost in the order of $450 for a relatively simple one, maybe $600 or $700 for a couple's will. If it becomes very complex, it can exceed that, of course. But given the value of the estate that we are looking at distributing, the potential claims that can be made, the complexities in certain family dynamics, it would be a very brave person, in my view, to prepare their own will, given that level of complexity.
Beautiful. Thank you so much, Lee. The other sort of other line of questioning we had was in terms of your superannuation. Obviously, you mentioned beautiful assets and things like that that people might have. How is superannuation managed in a will?
Well, I will defer to our wills expert, Natalie, who will address superannuation because it can be dealt with in a different way.
Beautiful.
Thanks, Lee. The superannuation isn't automatically included in a will, and superannuation does depend on the rules governed by the superannuation trustee. A superannuation trustee does vary from fund to fund. However, if you nominate and request that your superannuation is paid to your estate, then a person can include that in their will and decide how it gets paid or to who it gets paid to.
Beautiful. Thank you, Natalie. Really appreciate that. Another sort of question that we tend to get quite a bit is if somebody was wanting to develop a will and they were in hospital, is there anyone in particular who would be, I guess, best placed to witness that? And would that witness perhaps need to be someone who's able to sign statutory declarations in order to be valid? Because we talked about obviously valid wills. Just wanted to put that out there.
The answer is that any adult with legal capacity can be the witness to execute the will. The will provide that they include their full name and address. So the person can be found just in case there are any difficulties or questions arise as to the validity of the will. Having attended on many people over the years in the hospitals, the witness has been myself and either a doctor or a nurse who is available to assist in that regard. It doesn't have to be someone that's known to you. It just has to be someone who identifies, as I say, as an adult who has capacity and is a witness to the execution of the document. They don't need to be familiar with the terms of the will. Invariably, they will not be. They just simply need to cite the testator executing the will and witness the attestation of the will itself.
Beautiful. And Lee, does it have to be someone that isn't perhaps a beneficiary of that will?
Preferable that it's not a beneficiary of the will to be the to avoid any suggestions of undue influence or inappropriate contact. Preference that it's not a beneficiary.
Beautiful, thank you. And another question that we have around this sort of guardianship and wills space was, when you do have a blood cancer, but you're also a caregiver yourself, what is it that you perhaps might need to consider in terms of planning for your future and the ongoing care of your loved one? This might mean that they need accommodation or guardianship, or, as I say, wills. Any sort of thoughts in that space?
Well, no, very difficult, because all of these documents that we speak of refer particularly to the individual who's suffering as a result of a blood cancer or some other ailment. But it becomes very complicated when that person then is providing care to another person. You would have to ensure that that person also has in place proper documentation to enable the caregiver to be able to provide all of the care required if and when that person loses capacity. But again, depending on the nature of the relationship between the caregiver and the person receiving the care, as to whether they are the appropriate person to be appointed a guardian, for example, or an attorney. So these are the things that you would have to sit down with your solicitor and go through carefully as to the dynamics of the relationship that exists between these individuals.
Beautiful, thank you. And we've actually just had a bit of a question in the chat here that says, with the housing crisis, wouldn't it be more ideal to have the deeds of a property go to a relative or sibling? Any thoughts on that?
Anthony might be more qualified to answer that, but from a legal perspective, I mean, property can be transferred. If it's transferred from one party to another, there is, of course, stamp duty payable. The questions may arise as to the purpose of the transfer. If it's to avoid payment of debt, for example, then it can always be recovered back if party becomes bankrupt or whatnot. But generally speaking, there's, property is transferred pursuant to a will following the passing of the owner of the property. If it's for financial reasons, then that's something that Anthony may wish to address.
Beautiful, thanks, Lee. Antony, any comments on that space?
No, I don't think so. I think Lee's answered the question very well. There's going to be a set of exceptionally specific circumstances where that's really going to be helpful.
Yeah, absolutely. Thank you. In terms of, obviously, Antony, while we're speaking to you, question that we've had come up was in terms of income and benefits that people can apply for when they're obviously no longer able to work. And you mentioned job seeker, obviously, and the carer benefit earlier, but the question here was specifically around when might it be the best time to apply for those, knowing that there can be really lengthy delays in accessing government support and things like income protection, and perhaps any advice on how people might bridge that gap between finishing working and being approved for this type of support?
Short answer is it's nigh on impossible to bridge the gap. Centrelink are going to want to see that you have stopped work and you are no longer receiving income. So the short answer is no. It's just get onto Centrelink as quickly as you can. In terms of general suggestions for dealing with Centrelink, dealing with them online is often a less frustrating. I'm not saying it's not a frustrating process, because when you go into dealing with Centrelink, that's what you're going to expect, but everybody gets through it. So dealing with them online can often elicit a faster response from Centrelink. It also, for some benefits, when you get onto it, establishes an intent to claim, and when they do grant the benefit, they will pay from the intent to claim rather than from when they decided to approve the claim, which can be a few weeks sometimes. So they're going to just want to see you stop work. Now, There are very specific circumstances for terminal patients, and this is a lot more difficult for blood cancer patients. But what we would often do with stage 4 cancer patients was, when they stopped work, get them onto Centrelink, onto the disability pension, because they're eligible for what's called the manifest grant, that the 2 weeks to get it when the doctor signs off on a 24-month prognosis. They get onto that while they're waiting for their income protection to pay out, because you're not obliged to tell Centrelink about potential income, just your actual income. So that helps bridge the gap between income protection payouts and stopping work if you don't have savings, but there are assets and income tests for all Centrelink benefits. The benefit of that is you may lose the disability pension, but you don't lose being on the pension, you just lose the money and you get to keep the healthcare card, which, as I mentioned before, can be worth a couple of $100 a fortnight. So you may end up losing the money, but keeping the healthcare card. If the income protection ends in 2 years, then you would be back on DSP.
Thanks, Antony. And with regards to DSP, I had a question about for people who are on a disability support pension or an age pension, is there sort of any sort of threshold of amount of hours that they're able to work without it affecting their payments?
Yeah, absolutely. I think the current amount is $360 a fortnight before it makes a difference to your benefit. And after that, I think for pensions, which are the forever payments, DSP, carers and age pension, I think they're taking out about 50 cents in every dollar up to a certain amount. So if you want to know the actual amounts, I would search on assets and income test for the particular benefit that you're applying on. That will get you to the Centrelink page. And the Centrelink website is pretty good these days. There's a lot of complexity there, but that's the law, not Centrelink. So they do a reasonably good job of explaining it.
Beautiful. And I guess with that in mind, then, is there any sort of tips to navigating kind of how you might go about applying, or with that particular organisation? I know you mentioned obviously online tends to be a bit quicker than, you know, jumping on the phone and things like that. It can be a bit more sort of straightforward. Anything sort of there in terms of advice?
Not really. I think, you know, it's just online. I mean, if you've got that terminal and 24-month thing, I can tell you the form is an SA 494, but with a lot of blood cancer patients, as I said before, hematologists are optimistic bunch. They tend not to sign off on that sort of stuff.
Yeah, beautiful. Okay. You mentioned before, obviously, the healthcare card and things like that. And we're really mindful that the cost of accessing treatment, especially if you live in regional, rural, or remote areas in Australia, and there is quite a few of them, so that cost can be greater just based on obviously being in those areas, and it could be really different across the public and private sector. But is there anything you sort of recommend people ask of their treating team in terms of subsidies that might be available for them to sort of counter the cost of those medicines or treatments if they are having to pay out of pocket for anything?
Yeah, a really good question. And it's a really good question because there's no really good answer to it. It very much depends on the treating team and the hospital you're in. Like some hospitals have you will have access to excellent social workers who will have a word with the pharmacist at the hospital and say, look, they're going to have difficulty paying, that sort of thing. So I suppose if there's one tip there, it's see if you can get social work help. Tell them that you're having difficulty affording medicines, and I'd just refer people back to the PBS thresholds and stuff like that, and at least they know, because you have to apply for this. So understanding what the PBS thresholds are is going to forearm you for when you can do the application.
Great, thank you. And another one sort of just opening up there was, are there any, I guess, any particular services that provide individual support with budgeting for people with issues in addition to blood cancer, for example, that may have mental health difficulties, intellectual disabilities, addiction, cognitive changes that have occurred? Any sort of, I mean, I know beautiful Linda popped some things in the chat there regarding like debt and things like that, but just specifically regarding budgeting.
Yes, yes. Linda's popped in, I think, Money Smart, and that's an excellent first place to visit. There are financial counsellors are free to access in every state. Financial counsellors typically just deal with debts, though, but you will find within many of those agencies, they also have people called financial capability workers, and their forte is helping people find a way that makes budgeting work for them, because different people respond to different ways of budgeting, and the role of that person is to find the right way for that person to do it. You know, not everybody wants to do a spreadsheet. Some people literally prefer an envelope or two. So those agencies across the country are going to be Anglicare, Good Shepherd, Uniting, Salvos, and there are many other community organisations that may well have a financial capability worker there that's able to provide free support around finding the best way of budgeting for you. Community houses are also possibly a place to look. In Victoria, community houses are quite a common thing.
Beautiful. Thanks so much. And last couple of questions, just from obviously what we've gathered from those beautiful submissions prior to the webinar. Someone's written here, what are some considerations for people who are not on Medicare or aren't Medicare eligible? For example, they're overseas students or they're travellers or recent arrivals awaiting permanent residency, refugees, etc. What are some sort of considerations for them?
Yeah, good question. And again, that's a good question because there's no nice answer to this. Not a lot. For immigrants, they are supposed to come here with health insurance and stuff, so they may well have access to that, and then they're going to have difficulty possibly getting their health insurer to pay out, but that might require getting the support of a social worker if they're an inpatient. Just to make clear, most hospitals, the social workers have got to be an inpatient. Not all, but most. So, but again, I'd advise patients, ask, because if you don't ask, you definitely won't get.
And so in terms of, I guess, the diagnosis, we understand that it can impact certain types of insurance that people can get, but does it impact the ability to get insurance like travel or life insurance once you've already received your diagnosis?
Yep, absolutely. It's a pre-existing condition. And I guess, at risk of sounding a bit harsh, would you insure you now that you know what the risks are? And you can possibly get it through your super fund. Some super funds still have pretty wide open conditions for eligibility, so that would be worth checking as a first point. But if you were going out to the private market, you would almost certainly be subject to a pretty invasive medical questionnaire, which would reveal the condition, and they would probably decline your insurance on that basis.
All right. Thank you for that information, Antony. And I'm going to open this one up because I think it might be able to be answered by either Lee, Natalie, or Antony. Is around if people are on limited income and are needing legal advice, sort of what do you recommend, or who do you recommend they might go and see or have a chat to?
Brydens lawyers. We are more than happy to help where we can. There are legal aid officers, of course. There are community justice centres as well throughout every state. Every city would have a community justice centre that would be available to provide some legal advice and representation where required. But I don't know too many solicitors that would reject a plea for assistance or help from someone who finds themselves in a difficult position. So you could always approach solicitors, if, as I say, legal aid at first, or the law society of the particular state, and they will refer you on to many solicitors who undertake pro bono work, for example, in many instances, people who cannot afford legal advice or representation. But it's not unusual for any private law firm to be helping out if need be.
Thank you so much. And last but certainly not least, one of the other questions we had here was, and again, open to everybody, for people considering moving into aged care, how might they start to plan for that? And where could they sort of get accurate advice about costs or impact to their pensions or assets, for example? And how might that then impact on a will if they have one in place?
Well, just dealing with the will, I'll let Anthony deal with the financial aspects. But as to the will, it's just simply another asset that has to be brought into account and distributed under the estate. So if they sell their existing family home, for example, and buy into a residential facility, then it'll be another asset. I know that the arrangements with some of these residential facilities, nursing facilities, can be very complicated, as in that you buy in and then you are bought out, or the estate is bought out upon your passing. But again, as I say, it's simply an asset that will be taken into account for the purpose of distribution. But as to the impact on Centrelink entitlements and the like, I'll leave that to Anthony.
Excellent.
I'm gonna start with the presumption that they are committed to moving into aged care, that they haven't exhausted my aged care, because my aged care, while it has its flaws, provides quite a high level of care at stage 4. So I'm going to start with the presumption of that's still not good enough. If you're moving into aged care, I would say the best place, and particularly if you're navigating Centrelink on this, there are these people in Centrelink called FISOs, Financial Information Services Officers, and even better, ACSOs, Aged Care Support Officers. They're like super FISOs because they know about my aged care. I would suggest booking a time with either a FISO or an ACSO to talk about their proposal, and those people will be able to advise absolutely on what the options are with respect to Centrelink funding and managing that process of transition to aged care. You're getting it from the horse's mouth there.
Yeah, beautiful. Thank you, Antony. Really appreciate that. And appreciate, obviously, not only everyone who's submitted all these gorgeous questions for us to share and have our beautiful panelists answer for us today, but also, yeah, thank you so much to our knowledgeable panelists for sharing all of your gorgeous knowledge with us.
Okay. So that's been a phenomenal amount of information and a really lovely deep dive into a lot of the detail around financial planning, around advanced care planning, around appointing enduring powers of attorney, looking at wills, all the things we should all be doing anyway, before we end up in Sharon's position in a crisis and then having to do it backwards, because I know, Sharon, that's been a real challenge for you at times. So thank you to all our panel for generously sharing your knowledge, your expertise, and especially your time with us today. And most of all, thank you for all of you joining us. We really encourage you to use this information to start conversations with your healthcare team, with your family, with your friends, to help guide your health and your recovery and your quality of life by putting things in place. Just remember that we work really closely with third-party service providers like Brydens. And if you do go ahead with a product or service that's not directly from us, please make sure you check the costs so you don't end up with a rude shock or some unexpected cost. And if you have any questions or concerns, have a rummage around in our website. We've got some fantastic resources there, but also call us on 1800 620 420. Linda will put that in the chat, and just ask and we can help point you in the right direction. So thank you very much for attending and listening today. We value your presence and we also value your feedback. So when you get a little email from us asking, please give us your honest opinions. We really do use that to shape our program and inform what we deliver to you. So a recording of this session will be available in the next 1 to 2 weeks on our website. So if you missed anything, you can rewatch it, and you'll get a link to that email to you automatically if you're registered. So thank you again, everybody. And that concludes our webinar for today. Thank you so much. Bye.